The statute of frauds tells us that contracts for the sale of land are enforceable only if they're in writing. So, is a verbal land sales agreement ever enforceable? The court dished the dirt on that question in Sullivan versus Porter. Merval and Susan Porter owned a 52-acre farm that included a farmhouse, a barn, and stables. Joan Sullivan managed the stables. In August of 2000, Merval verbally offered to sell the entire farm to Sullivan and David Andrews, whom we'll call the buyers, for $350,000, with $20,000 down, and Merval financing the balance at between 5 and 7% interest. The buyers verbally accepted. Merval said he'd have his attorney start the paperwork. The buyers told Merval that they'd refinance their house to obtain the down payment. In September, the Porters moved out and gave the keys to the buyers, who started making improvements to the stables and trails. The parties next met on November 25th. The buyers tendered $10,000 toward the down payment. The Porters said they didn't want any money until the paperwork was ready, but eventually accepted $3,000. Thereafter, the buyers opened their stabling and riding business and began renovating the farmhouse. In June of 2001, Sullivan sent the Porters an appraisal valuing the farm at only $250,000. But Sullivan reaffirmed that the buyers intended to abide by their agreement. Merval then offered to sell for $450,000 with $50,000 down. After negotiations failed, the buyers sued the Porters, seeking an order for specific performance. After a trial, the jury determined that a contract existed. The trial court ordered the Porters to execute a purchase agreement for $350,000 to be financed by the Porters as agreed. The Porters appealed to Maine's Supreme Judicial Court.